The Supreme Court Justice Clarence Thomas, who claims to be an originalist, has had several controversies swirling around him that started with his confirmation hearing. Anita Hill testified that Thomas sexually harassed her when Thomas was her boss at the Equal Employment Opportunity Commission. See NPR article titled Anita Hill Started a Conversation About Sexual Harassment. She's Not Done Yet. End of quote. More recently, it has been disclosed in several articles that Thomas failed to report on his disclosure statements gifts made by wealthy benefactors, many of whom are major contributors to far-right causes. See an article titled, quote, A Quick Guide to Justice Clarence Thomas's Ethics Scandals, published on October 10, 2023. An example from that period last year was an article published by ProPublica in August of 2023 that Thomas had accepted gifts, likely valued in the millions of dollars, that included 38 destination vacations, 28 private jet flights, 8 helicopter flights, a dozen VIP passes to sporting events, and 2 luxury stays in Florida and Jamaica. The ProPublica article is titled, quote, Clarence Thomas's 38 Vacations, the Other Billionaires Who Have Treated the Supreme Court Justice to Luxury Travel. Thomas, in my opinion, views himself as unanswerable to anyone, probably including God, an arrogant and haughty attitude that he has, which is typical of many who have been given power that cannot be recalled as a practical matter except through death by natural causes or voluntary retirement, which he does not appear likely to do. I had forgotten about one potentially serious claim that involves Thomas when he borrowed $263,230 to buy a luxury motor coach. I was reminded of that issue when I read a CNBC article titled, quote, Supreme Court Justice Clarence Thomas pressed on questions over friend's $260,000 RV loan, published earlier this month. Thomas paid only interest on the loan, and his benefactor, Anthony Welters, later forgave the principal amount. There has been an ongoing investigation of this matter by the U.S. Senate Finance Committee that obtained documents from Welters regarding this loan. I am basing my comments on a memorandum prepared by the Senate staff dated October 25, 2023. Thomas did not disclose the debt forgiveness in his ethics filings, which is normal for him. The forgiveness occurred in 2008. At page 4 of the Senate staff's memorandum, it is stated that Thomas has not stated whether he included the forgiveness of debt as income on his tax return. I believe, without checking further, that the 6-year statute of limitations applicable to substantial tax underpayments has expired for an IRS assessment of interest and penalties. I'm not familiar with what the statute of limitation is for a criminal tax fraud charge. The legal issue is that debt and forgiveness is considered to be income. A failure to include the amount forgiven as income would arguably constitute tax fraud, particularly given the size of the forgiveness and the amount of it. The only other tax treatment which would be a gift by Welters, and he would have had to file a gift tax return and pay a gift tax, if he categorized the debt forgiveness as a gift. It would be a simple matter for Thomas to say that the amount forgiven was included as taxable income if that was in fact done. He has not made that kind of statement, and his only statements through his attorney have been evasive on that issue. Welters needs to be subpoenaed and asked under oath how much of the principal amount was forgiven. The implication in the staff comments is that memorandum is that all of it was forgiven, and whether Welters filed a gift tax return covering that amount. If not, then it would be too late to claim that it was a gift. It was a forgiveness of the principal amount, which would have been income to Thomas that he needed to report on his tax return.